So let's start first of all with news gathering. First Amendment in the U.S. Supreme Court. The Supreme Court has generally sided with the media with respect to protection under the First Amendment. One thing that we'll talk about more with confidential sources is Bransford v. Hayes, which found that the press does not have a guarantee to special access to information that's not available generally to the public. There are, again, protections for the press that apply to all people in a variety of issues, and one is traditional public forums. So journalists can gather news where activities could be observed by passers-by. Streets, sidewalks, parks, and similar places are known as traditional public forums. That's why, for example, when you see the cameras following someone, that's why most everyone's parked out on a sidewalk. The restrictions are placed when disasters occur, there are criminal investigations, or with respect to military locations. And some states, California, Ohio, and Virginia, have actually put into place statutes that do give journalists access to emergency and disaster locales. Access to judicial proceedings. Richmond Newspapers v. Virginia in 1980 held that newspapers, but not all media, and the public have access to trials. That's why you'll see in some states that there will be an allowance to have cameras in the courtroom. In others, you won't. You can not have audio recordings in most courtrooms, and you cannot have any type of camera recording of federal courts. There are restrictions to what are called non-public forums, and these really vary from place to place. So that California placed restrictions based on the number of requests to interview Charles Manson and the Menendez brothers. In Pennsylvania, it is not possible to do a television interview or on-camera interview with inmates. Individual states and wardens do allow access, and executions are not allowed to be photographed or televised, but generally there is a representative of the press at an execution. Other non-public forums. Military bases and battlefields are not public forums. Journalists in Vietnam were granted wide latitude because it was not a declared war. But since Vietnam, there have been significant restrictions and censorship in the 1983 Grenada invasion, the 1990 to 91 Gulf War. Embedding was allowed during current wars, but again with censorship. Private businesses that are open to the public don't necessarily lose their private nature simply because the public is allowed to use the locale. So for example, in shopping malls, you can't simply go in there and start photographing. Paparazzi, after the death of Lady Diana in France, that prompted a great deal of interest throughout the world, including the U.S. to implement paparazzi laws. But the legislation has consistently failed in Congress. News gathering techniques. The Supreme Court has never ruled on a reporter's liability for publishing information from illegally obtained documents. So, for example, if we go back to the Pentagon Papers case, those were technically illegally obtained because they were given to the newspapers after having been copied illegally. An individual reporter, however, may face state laws for illegal activities. So that in 1998, the Cincinnati Enquirer had a reporter who tapped into the voicemail of Chiquita Brands, and he was sentenced to probation and settled, the newspaper settled a defamation case to the tune of $10 million. The newspaper described the action as unfortunate, embarrassing, and a failure of modern investigative journalism. Other techniques. Reporter given a tape recording between a union negotiator and the president of the teachers union included a discussion of blowing up the front porches of uncooperative school board members. And the Supreme Court said that the recording, although illegal, did not outweigh the reporter's First Amendment rights to broadcast it. There are also things that are called consent laws for recording. There are one-party consent states and two-party consent states. A one-party consent state, like New York, essentially says, I, the reporter, can consent to the recording by audio or by video. Pennsylvania happens to be a two-party consent state, so therefore the individual who's being interviewed and the reporter both have to agree and consent to it being done. What this prevents in two-party consent states is undercover camera investigations. Journalists have successfully been sued for providing false identities and references, specifically in the Food Lion versus Capital Cities ABC. I was there at the time. I wasn't involved in the case, but what happened is that reporters and producers went in to look at the quality of the preparation of the food and at Food Lion, which is a big supermarket company, and they provided false information on their applications. So those are just a few things with respect to news gathering. I apologize for the sirens in the background, but I guess it's appropriate during a discussion of journalism and the law, and particularly news gathering. So that's all for now, and we'll see you again online. Thanks very much.